Welcome to Season Synopsis.
Hello and welcome to the podcast which decodes the law surrounding Prevention of Money Laundering Act. This is a very complex act and the honorable courts all across India have passed several judgments which makes the law surrounding the PMLA even more complex. My attempt is to break down each judgment into three simple segments for a better understanding of the law in general. The three segments that I am going to break down each judgment is prosecution submissions, defense submissions, and finally the observations of the court. Let us start with the first judgment in the case of Ram Kishore Arora versus Directorate of Enforcement. What were the prosecution submissions in this above case? The Enforcement Directorate or the ED began by asserting that the arrest of Mr. Ram Kishore Arora was valid under Section 19 of the PMLA. They contended that, point number 1, grounds of arrest were handed over to the appellant. He read them and thereafter signed on each page. The second point, on the last page the appellant acknowledged the receipt of the arrest grounds. Their most prominent legal argument was that in the decision in Pankaj Bansal's case by this Honorable Supreme Court of India emphasized furnishing of grounds of arrest in writing was per incurium. Per incurium means it was not legally valid or legally did not hold the field. Why? They said so because as per their arguments, it deviated from an earlier and binding three-judge bench decision in the case of Vijay Madanlal Chaudhary versus ED and others. Therefore, according to the ED, a two-judge bench cannot overrule or sidestep the precedent of a larger or an equal bench. Therefore, the decision passed in Pankaj Bansal's case lacks binding authority with respect to Section 19 of the PMLA. Finally, the ED argued that Pankaj Bansal's case should only apply prospectively, that is, henceforth, moving forward, and cannot retroactively affect arrests made before that judgment of Pankaj Bansal was passed. Now let us check the submissions by the defense. Representing Mr. Arora, the defense rebutted these claims strongly. First, they argued that the fact that ED filed the arrest grounds now suggests those grounds were not served at the time of arrest. Second, merely showing the arrest grounds for signature does not qualify as serving them. There must be actual furnishing of a copy. Third, they leaned in on the decision passed in V. Senthil Balaji's case and Pankaj Bansal's case to assert that the grounds must be served at the time of arrest. Fourth, importantly, they stressed this was not just an irregularity but rather an illegality. Non-service of grounds vitiates the arrest entirely. The principle they cited was the law prescribes a procedure and it must be followed as per exactly that procedure. Any deviation makes the act in itself a nullity in law. Further, the defense claimed that the illegality is incurable. You can't fix it later by producing the grounds of arrest post facto. They placed reliance upon judicial decisions, like in Saurashtra Kutch Stock Exchange Limited case, which supported the idea that judgments generally have retrospective effect. So, the decision in Pankaj Bansal's case should apply to the present case as well. Now, let us check what were the observations of the court. The court approached the issue with depth and a nuance. Firstly, it re-examined section 19 of the PMLA and the Honorable Supreme Court's ruling in the cases of Vijay Madan Lal Chaudhary's case, Senthil Balaji's case and Pankaj Bansal's case. A peculiar one phrase stood out, that is, as soon as may be. To interpret this, the Honorable Court referred to older constitutional judgments, including the case of Abdul Jabbar Butt, which interpreted the expression as soon as may be to imply that it means as soon as possible, and Durga Ghosh, which reinforces the same interpretation. Thereafter, the court concluded that the expression as soon as may be implies within a reasonable time, ideally within 24 hours of arrest, aligning with the constitutional safeguards under Article 22 subclause 1. Critically, the Honorable Court analysed the phrase henceforth used in Pankaj Bansal's case. It held that this term implies a prospective application, meaning that the obligation to furnish written arrest grounds applies only to arrests made pursuant to the passing of the judgment. Therefore, it cannot be applied retroactively to Mr. Arora's arrest. Finally, the Honorable Court noted that Mr. Arora did sign the grounds of arrest. While he claimed they were not furnished, the fact remains that he was informed and acknowledged them, thereafter satisfying both Section 19 of the PMLA and Article 22 subclause 1 of the Constitution. Thereafter, the court concluded that the arrest was legal and in compliance with the law as it stood before Pankaj Bansal's case. And that's a wrap on today's episode. The Ram Kishore Arora's case helps us better understand how timing and process matter when it comes to arrest procedures under PMLA, and how judicial language like the expression henceforth can shape an entirely legal representation and interpretation. In the next episode, we will see the two judgments heavily relied upon in the Ram Kishore Arora's case being Senthil Balaji's case and Pankaj Bansal's case.